Hello, this is the Legal Aspects of Healthcare Administration, Group 3, Chapter 12, Baby Charlie and End-of-Life Decisions case. I am Scott Kroll. Also in our group is Lutunde Lark, Raquel Lewis, and Sumibola McKindy. The purpose of this video is to discuss the Baby Charlie and the End-of-Life Decisions case. We're going to address a number of issues, including the informed of parents to the minor infant, including guardian consent and human research, discussion of patient rights and the treatment versus fetal care, medical negligence and vicarious liability, advance directives, do not resuscitate living wills, physical orders, abuse and neglect laws and how they apply providing fetal cases, medical record access by parents, how two professional code of ethics apply, and other legal ethical issues identified in the group. The background of this case, we're going to talk about Charles Matthew Williams, Charlie Gard, an infant boy from London born with mitochondria DNA depletion syndrome, MDDS, a rare genetic disorder that causes progressive brain damage and muscle failure. MDDS has no treatment and usually causes death in infancy. The noted ethical controversy was due to the medical team, and the parents disagreed about whether experimental treatment was in the best interest of the child.
Hi, my name is Raquel, and I will be going over the informed consent and human research consent. I will also be looking at ethical considerations. I will make mention of medical records access when it comes to parental rights, requesting medical access for their children's records, what information can be shared with the media, and what information should or should not be redacted from medical records. Children are defined as individuals who have not reached the age of legal consent for research and treatment purposes. When minors are involved in research, parental consent is required before the child undergoes any kind of treatment or take part in any kind of research operations. In addition to secure the consent of the child, in the event that is required, parental authorization is also required. This allows the parent or guardian to be 100% involved in the study and make informed decisions on behalf of the child and in the best interest of the child. This informed consent should be documented in writing for study involving minors under the age of 18 and those who are otherwise physically or mentally challenged, who are not able to make these decisions on their own. The parent or representative should have adequate time to, however, ask questions, weigh risk, and discuss involvement with people who are consenting with others or as appropriate. Next slide. Ethical consideration when it comes to human rights being involved in human research is to demonstrate two important procedural safeguards. These are the prior scientific and ethical evaluation by the ethics committee, followed by obtaining information consent by prospective study subjects. Both precautions are modified for studies with children, given the children's ability to make informed decisions on behalf of themselves. The informed consent process, however, implies that persons who are not capable of deciding on their own should be protected, which means requiring permission from capable individuals who are authorized to give consent on their behalf. Parents or legal guardians serve this important function for children who are not able to make decisions on their own. Only persons who have appropriate capacity and are legally empowered can provide effective informed consent for individuals. In all other situations, parents and or guardians provide permission for diagnosis and treatment of their children with the assent of the child whenever this is appropriate. Therefore, parental permission serves to protect a child while the child's capacity for self-determination matures.
Hello, my name is Iyutande Rock Rivers. I am working with Group 3. I will be discussing Patients' Bill of Rights and futile care. The guidelines for the Patients' Bill of Rights was established in 1973 by the American Hospital Association. The American Hospital Association consists of 5,000 hospitals, healthcare systems, networks, and providers. There are 43,000 individual members. The Patient Bill of Rights became a law on March 23, 2010, renamed the Patient Protection and Affordable Care Act, which was signed by President Barack Obama. The law provides rights and protections to patients not only in interactions with physicians and medical facilities, but also with healthcare insurance providers. Next slide. The Patient Bill of Rights consists of the following guidelines. The right to emergency treatment, regardless of ability to pay. This falls under EMTALA, or Emergency Medical Treatment and Labor Act. The patient has the right to respect, no discrimination. Treatment with respect and dignity, regardless of race, sexual orientation, and religion. The patient has a right to informed consent. A patient receives sufficient information about their treatment in understandable terms. There is a right to refuse treatment. Patients have the right to refuse treatment even against medical advice. Next slide. The patient has a right to choose a provider. A patient can select a provider for their care and does not have to go with their referred provider physician. They have a right to privacy. A patient can decide to whom, when, and to what extent their private, individual, identifiable health information is released. They have a right to appeal. Patients have the right to a fair review or appeal of any complaint against a physician, hospital, or other healthcare provider. Patients also have their own responsibility to care for themselves by following the treatment plan assigned to them by their physician. Next slide. Patients have a right to treatment. This falls under the Universal Declaration of Human Rights, codified in Article 25 by the United Nations. And the Covenant on Economic, Social, and Cultural Rights includes the right to everyone to enjoyment of the highest attainable standard of physical and mental health. Next slide. Futile care is defined as medical care that does not improve the patient's prognosis, comfort, well-being, or general health. The American Medical Association offers guidelines to physicians regarding the issues of futile care. One is have discussions with patients or representatives about the specifics pertaining to their care, including quality of life. Patients are also assured that medically appropriate care, including appropriate system management, will be provided unless the patient declines. Patients must agree on plan of care consistent with the goals with sound clinical judgment. Guidance of the organization's ethics committee may be used to help patients understand the treatment when it is medically inappropriate, but with respect to patients' rights to appeal. Care of the patient may be transferred to another facility if the patient does not want to abide by the request of the current physician. If transfer is not available, the current physician does not have to treat that patient. Next slide. AMA suggests the following policies be put in place regarding futile care. Acknowledge the need to make consent judgments about care to individual patients. Provide support to the physician, understanding that their judgment was used in the decision about the care of the patient. Takes into account community and institutional standards for care. Scientifically sound measures of function or outcome were used to determine the treatment of care, even if it is determined that it is futile. They want to maintain consistency and due process in the event of disagreement about whether an interaction should be performed. Thank you, and that ends the presentation on patient rights and futile care.
My name is Simibola Makinde, one of the Ethics Committee members, Group 3. The topic for discussion is the case study about baby Charlie and end-of-life decisions. I'll be discussing about medical negligence and vicarious liability, also abuse and neglect laws, and how they apply to providing fetal care or withholding care. First of all, we're going to talk about medical negligence and vicarious liability. Medical negligence is considered as the substandard care that is provided by medical professionals to a patient, causing further injury to them. In this case of Charlie, the medical professionals provided medical care to save baby Charlie's life by putting him on life support as a last resort. So we would say, medical negligence did not really occur in their care for baby Charlie. However, there are different ways medical negligence can occur, and this includes misdiagnosis, surgical errors, or even wrong treatment. Sometimes even an omission can be regarded as medical negligence. And then we have vicarious liability. This is a legal binding document that ensures that a person or an entity is liable for an injury to a person. And this only happens when the two parties have a legal relationship. For a good example can be like a factory worker who's an employee in a factory. When a factory worker is injured at work, the factory is liable for the injury, even though they did not harm the person physically. The machines did, but the factory is responsible because the contract, there's a legal binding contract, legal relationship between the employer, which is a factory, and the employee, which is the factory worker. That is, whatever happens to the factory worker, the factory, which is the employer, is liable to treat the employee, which is the factory worker. So they have a vicarious liability between them. So the employee is regarded as a vicarious liability because there's a legal relationship between the both of them. However, in baby Charlie's case, this doesn't apply because there is no legal relationship between baby Charlie and the medical professionals to establish a vicarious liability.
Hello, my name is Iyutande Lark Rivers. I am part of Group 3. I will be discussing advanced directives. The state of Maryland describes advanced directives as a legal way for an individual or declarant to direct their medical care, particularly treatment preferences in an emergency or near end-of-life event. Advanced directives includes the name of a healthcare agent or proxy that can make decisions for a declarant if they are unable to do so themselves. The patient and their family understands the guidelines as it pertains to witnesses, notarization, and other specifics. Directions must be followed correctly. Advanced directives are available in all states, but the guidelines may be different. Next slide. Power of attorney. A medical or healthcare power of attorney names a person to make decisions for them when they are unable to do so. In some states, this directive may also be called a durable power of attorney for healthcare or a healthcare proxy. Power of attorneys must meet state requirements, is not a person that is part of your medical team, willing and able to discuss medical care and end-of-life issues with you, be trusted to make decisions that follow your wishes and values, and be a trusted advocate when medical disagreements arise. Next slide. Living wills are a written legal document that outlines the medical treatment someone would or would not want to be used to keep them alive, as well as preferences for other medical decisions such as pain management or organ donation. Living wills can outline items such as CPR, mechanical ventilation, tube feeding, dialysis, palliative care, antibiotics, organ tissue, or full body donation. Next slide. Do not resuscitate or do not intubate. The patient only has to notify their physician of their preference, and it has to be in their chart. It is not an advance directive. Physician orders for life-sustaining treatment is often used by patients who have already been diagnosed with a serious illness. Physician orders for life-sustaining treatments are doctor-ordered instructions that ensures in a case of an emergency, you receive the treatment you prefer. The form is completed by your physician based on the content of your advance directives, the discussions you had about the likelihood of your illness, and your treatment preferences. The items included may be similar to a living will, but may be more in-depth to include items such as requests not to be taken to an emergency room, requests not to be admitted to a hospital, or pain management. Next slide. Advance Directives Overview. Advance Directive documents should be kept in a safe place with a copy to your primary care doctor. Discuss your advance directives with family and friends so they understand your wishes. Keep a copy in your wallet, especially while traveling. Advance directives can be changed at any time. A review of advance directives should be done when you have a new medical diagnosis, a change in marital status, or as often as a person deems fit. Advance directives are clear and keep in alignment with a person's wishes. Thank you.
Then we have abuse and neglect laws. Abuse laws are considered as an intentional action that causes harm or injury to another person. Some of the cases that falls under the abuse laws include sexual harm and physical harm. Someone who harms another person purposely can be convicted under this law. So, in reference to Charlie's case, some of the medical staff and institutes denied him services, citing that he had poor health. This can be termed as abuse, as they deemed him irrelevant for their institute because they didn't bother to provide some certain type of health services for him, because they were like, oh, there's no point in providing services to him because he has a poor health and is probably not going to survive. But regardless, it is important to provide health services to people regardless of if they have poor health, as long as they have rights to it, because it is Charlie's patient's rights for him to have access to these resources. And then we have neglect laws, which also allows an individual to act in a way that aligns with certain standards of conduct. If one is found in breach of these laws, they are deemed to act against the ethical rules. So in reference to the case of Charlie, the medical professionals basically I'd broken the neglect law in terms of denying him service, because neglect is a passive form of abuse. And also, they had also caused like emotional harm to the parents and also to Charlie by not providing him the services, and also physical harm to Charlie too. And also, if they had switched off the ventilator, Charlie would immediately die. However, they stopped performing certain care because they believed it would be productive or yield sensible results. And this can also be classified as neglect and also a form of abuse. However, neglect laws can also be used in cases where individuals are withholding treatment for patients. And this also happened to Charlie. The law dictates that all people are viable to receive any medication regardless of their sex, color, or age. And then legal actions could be taken on those who deny orders of treatments. However, we can see how this neglect law intertwines with future medical care and also with withholding care. Future medical care is considered as the continued care services for a patient, especially when there is no hope for a cure. And we can see that in Charlie's case, where what's going on with him is a very complicated health issue, and there's a low probability rate of survival. On the other end, withholding care is when lifelong treatments are discontinued, for example, a ventilator or dialysis. Charlie is actually placed on a ventilator, which is a life support services. So we can say that the medical professionals did not withhold care from him in that essence, but we're actually performing some future medical care for him. And the medical professionals did not withhold care as they did. All they could do was keep him alive by putting him on a ventilator. But they were able to provide future care, knowing fully well that there was no hope or for a cure or survival. And we're just gonna examine some legal and ethical consequences that could result, from this ethical dilemma. So, in reference to Charlie's case, there are legal consequences that can befall healthcare institutes if such cases are not resolved, and they're not limited to the patient deciding to sue the organization for failure to uphold their sworn duties. And we can see that in them denying him some certain care because they thought there was no point giving him this care, and there was no point giving him these resources since it was going to die. Also, taking legal action may also lead to further escalation of the problem, causing harm to the reputation of the healthcare institute. Also, depending on the reputation of the healthcare institute, I believe that if the case was not resolved, it could, like the way the case became an international debate. The case study became an international debate where everybody was chipping in and saying, oh, what they did was morally, ethically right, and another group was like, oh, it wasn't ethically appropriate. All this can also cause like a scandal, and also a diminished reputation in how and also in how they provide quality care to their patient, and this could affect the reputation of the healthcare institute. So, and also this could lead to unnecessary high cost of litigation and fees that could have been avoided in the first place if this case was not resolved. In conclusion, if the patient is of sound mind and decides on a certain decision, I believe the hospital should support the decision and offer recommendations. There are some actions that looks bad but are ethically correct, like ending a baby's life. It looks bad because a baby is a life that's been brought to life, and also a human being. At the same time, a baby who is suffering and struggling to stay alive and also in pain and agony, it is important to identify cases that shows that if a certain decision is made, the result fails to produce an sensible result. So if keeping baby Charlie, it's important to examine that a life was going to help baby Charlie, live longer, stay alive, and be productive. I believe the right decision was to put him on life on life support. In the case of Charlie, it is ethically correct to stop life support to end the suffering of the boy. Keeping him on life support was extending his suffering with no hope of survival, and which at the end of the day, the doctors and the parents were able to agree that that was what was wrong with Charlie, and it was eventually able to take him off the life support and end his suffering. In this case of baby Charlie, parties involved should ensure that they have exhausted all the available alternatives before they decide on an ethical solution. I believe medical professionals should try to examine all alternatives and medical alternatives to save baby Charlie. I believe they did that before they eventually arrived at the ethical solution to eventually take him off life support. There was no means of survival. There was no way it was going to survive, and it was causing more pain and suffering for the baby and also for the parents, and also I would say incurring high costs of medical bills also for the parents, because the longer baby Charlie stayed on life support, the more the cost of staying in the hospital was. And seeking alternative should be something medical professionals should basically do, before they make a huge decision. And in this, I'm pretty sure, in this ethical dilemma concerning baby Charlie, I'm pretty sure they examined all the options that they could. And because by doing so, on both ends, both parties involved, they'll be fully satisfied with the common decision, and there will be no legal consequences. And if both parties can agree and say, oh, this is what we're going to do, and there's not going to be a legal fallback by saying, oh, you did this against my will, or you did that against my will. So it's important to basically explore every alternative before arriving at the ethical solution. And in this case of baby Charlie, the ethical solution was to end baby Charlie's life, as sad as it was.
HIPAA laws permit individuals other than the patient to act as their personal representative for the purpose of exercising their privacy rights. This means making decisions about releasing confidential information if the patient is not legally competent to make independent decisions. Because minor children are not generally permitted by law to make these decisions about their rights, HIPAA recognizes that parents, in most instances, will act as their personal representatives. In many cases, this works well to facilitate medical treatment and to conduct research on the child. However, some states have legal guidelines to clarify when the parents are not married to each other, both parents have the same equal rights to access the child's medical records. This applies regardless of who has full custody of the child at any given time. The parental access laws become problematic when the parent's interest and that of the child may differ. However, there is one exception to this rule. However, parents' access could be denied if a healthcare provider determines that the parent's access to the child records may endanger the child or the parent, or if the child is subject to abuse or neglect. In that case, HIPAA laws blocks that parent from having access to the child's records. The partnership between the healthcare industry and the media industry has developed over the years. Hospitals require media support to market programs, new technology, and they also depend on the media to deliver timely information, to discover interesting newsworthy patients, and locate clinical specialists to debate the newest medical breakthroughs, all within the constraints of publish and broadcast deadlines. There's however a frequently narrow line between confidential information and what the public has a right to know. Given that the hospital's primary role is to safeguard its patients' privacy and health information, the following is a guide requesting and releasing patient information. Hospitals and the news media have a shared obligation and interest in ensuring that critical information is reported immediately and widely available. Hospitals and physicians have a moral and legal obligation to guarantee that their patients receive proper and safe care, to preserve their patient rights to privacy and confidentiality, and to comply with federal and state regulations, including HIPAA privacy requirements. This includes acknowledging that the patient's medical record is private and confidential, and that the information contained is personal property of the patient. The release of information lies on a mutual agreement between the parent and or the guardian of the child and the healthcare facility. So the record request will be facilitated by a written consent by the parent. Additionally, a news reporter may obtain videos of an infant within the hospital when there is a written consent present. For example, a news reporter may be able to capture a video if there's no other children around whose parents may have not have a written consent. They may not, however, obtain videos in areas where sensitive information may be present or may be captured, or where they have sensitive equipment present. Generally, the news reporter may medical records access and the redaction process. There is some information that may need to be redacted before the release of the medical information. Any information that is likely to cause significant harm should be redacted from the medical records prior to release. For example, if the access is likely to cause harm, such as physical or mental harm to the patient, access should be withheld. Other information that should be redacted is that of third parties. For example, in the event of a child abuse case, information of the person who made the report, such as a relative or maybe a healthcare professional, should be redacted. Information that includes address, phone number, and name should also be redacted of these third parties. When it comes to work product exclusion, work product is material or mental impressions developed in anticipation of a litigation, for trial, or for third-party representatives, including third-party attorneys, consultants, employees, or agents. A communication made in anticipation of a litigation for a trial between party and a party's representatives, or among a party's representative, including attorneys and employees and other agents. There is one exception to this work product exclusion, and even if it is made in anticipation, even if it is prepared in anticipation of litigation or trial, the following work product is not protected from discovery, and that is information discoverable by concerning expert trial witnesses, witness statements, and contentions. The work product rule, however, implies that witness statements in any medical case is required to be disclosed and prohibits any rejection for such statement. Therefore, even if there is a pending litigation, witness statements will not be protected by the work product.
In this section, we're going to discuss how the two professional codes of ethics apply. Also, we're going to talk about other legal and ethical issues that were identified by our group. On this slide, we're going to talk about professional code of ethics for healthcare executives. What the slide contains are 10 ethical principles that help direct the healthcare executive on their proper course of action. The ethical principles are self-interest, personal virtues, religious injunctions, government requirements, utilitarian benefits, universal rules, individual rights, economic efficiency, distributive justice, and contributive liberty. This slide talks about the professional code of ethics, or the code of medical ethics for physicians. These are principles adopted by the American Medical Association, and they're not laws, but codes of conduct for honorable physician behavior. These medical ethics include a physician who will be dedicated in providing competent medical care, uphold the standards for professionalism, respect the rights of patients, colleagues, and others, continue to study and apply advanced knowledge to maintain a commitment to medical education, provide appropriate patient care, except in emergencies, regard the responsibility of the patient as paramount, and support medical access to medical care for all people. These ethical standards fit perfectly or very closely into the case we're talking about, and we'll go into it in a little detail on the next slide. This next slide talks about the professional code of ethics and other legal issues. Charlie Gard's case raises significant ethical questions about healthcare, experimental treatment, quality of life, and the decision making. According to Wilkinson, the important role of ethics in cases like this is to help clarify key concepts, identify central ethical questions, and separate them from fact. And that's going to be the subject that's used for critical scrutiny. This next slide separates out the factual questions from the ethical questions. So what you see on the factual questions are very specific, very factual items that there's no contention on that. The example here's a good example was Charlie's on question number 1 was Charlie's level of awareness and recognition. Go down to question number 8. How long could he live with continued life-sustaining treatment? These are just very factual questions that can be answered in a very methodological manner. The ethical questions, on the other hand, are the ones that need to be debated and talked through. The two main driving sides of the question is it the right thing to do, and how should the decisions be made? And that is what Wilkinson is trying to get across, is we need to separate out the items that shouldn't be contested to the items that have to be discussed. So our group came up with other legal issues and or ethical challenges. And the first and foremost one is the parents' role in decision making for their children. We need to focus on looking at the rights of parents in decision making and whether the courts can intervene on a variety of cases. Next thing I want to look at is experimental treatment. Should we have a lower threshold allowing more access to types of patients that have no other options? Next item is role of resources. With the limited resources available, is it wise to apply very costly services, denying other patients the right to have access to this limited care? Then the role of the courts. There needs to be a fair way of resolving disputes. Parents cannot have final say in medical decisions for their children, but nor can doctors. There just needs to be a method of arbitration. That's a legal issue. Then the last one is the decisions, ethical decisions versus clinical decisions. Once again, factual versus the real questions we need to ask. There needs to be a reasonable disagreement and a method of settling between the medical facts and then the ethical questions. This is the end of our group presentation. Thank you for viewing it. We are all parents in our group, and we all talked through this. We concluded that regardless of whatever side of Charlie Gard's case you're on, nobody feels good about the decision-making process, nor the final decision. Our takeaway here is that regardless of if you participate as a medical administrator or a medical practitioner, it's essential to stay within the ethical principles established by your professional code of ethics. Thank you very much.